Hello everyone, welcome to CLAT 1. Today we'll be discussing some major doctrines that you'll stumble upon your CLAT journey and even in a legal career. These are very important doctrines that are going to help you become a good lawyer. So today we'll be discussing the very basic ones which can come in your CLAT examination. Okay, so the first is doctrine of privity, which you might have heard. Okay, so only the parties to a contract can sue or be sued on it. A third party cannot enforce a contract even if it was made for their benefit, which means that only parties that are a part of the contract can sue or be sued on it. Okay, and any third party, even if they are benefiting from it, cannot enforce or sue someone. For example, let's say the example A promises B to pay rupees 1 lakh to C. If A doesn't pay C, C cannot sue A. So A here is the one who is promising. He is the promiser. B is the promisee, and C is a third party because C is a part of the contract as a third party, but is not directly in a promiser or a promisee. Okay. So C was never a party to the contract, and B was. So C cannot sue A if A fails to pay him. Okay. Some exceptions are beneficiaries under a trust, family marriages, settlements, assignment of contract, acknowledgement, or estoppel. Some major case laws are the Dunlop versus Selfridge, MC Chaco versus State Bank of Travancore. Now let's move to the next doctrine, which is the doctrine of frustration, which comes under Section 56 of the Indian Contract Act 1872. So the doctrine of frustration says a contract becomes void when when its performance becomes impossible or unlawful due to an event beyond either party's control arising after the contract was formed. It means that if a contract becomes impossible to perform, it becomes void automatically. Okay. Let's see the example. A agrees to supply goods manufactured in his factory before delivery. The factory burns down completely. Performance is now impossible. The contract is frustrated. Also, one major part of the doctrine of frustration is that the thing that is making the performance impossible should be beyond the party's control. For example, here there was a fire which burned down the factory. Therefore, the contract becomes frustrated and hence void. Okay, and also mere hardship, delay, or commercial difficulty does not amount to frustration. The event must make performance truly impossible or unlawful. So let's take an example. For example, if I have to deliver goods to someone, and if there is heavy traffic, it does not make the contract frustrated because it is still possible to deliver the goods. Okay, so if there's a hardship, the contract cannot become void. A major case law is Satyabrata Ghosh versus Mungiram Bangur. Now let's move to the next doctrine, which is the doctrine of mutuality, which is the mirror image rule, which we also studied in the last video. An acceptance must exactly match the terms of the offer. Any variation turns the reply into a counter offer, which kills the original offer. Okay. So it says that the offer and acceptance must be a mirror image of each other. Okay. Offer must be accepted as it was made by the promiser, offerer. Any changes to the offer will make it a counter offer and not the original offer. The original offer subsequently expires. Okay, let's see an example. A offers to sell his bike for rupees 60,000. D replies, I'll take it for 45,000. This is a counter offer. Okay, so the A offered to sell his bike for 50K and not 45. B says that he wants to buy for 45. This means he's making a counter offer and it's not an acceptance. A major case law is Hyde versus Wrench. Let's see the next doctrine is the doctrine of consensus ad idem. So consensus ad idem is a Latin term that means meeting of minds. Both parties must agree on the same thing in the same sense. If there's a bilateral mistake as to a fact essential to the agreement is void, which is under Section 20 of the Indian Contract Act. Okay, it means that both parties must agree on the same thing. Okay, and in the same sense, and the mistake of facts will make the agreement void. An example to it is A agrees to sell the car in his garage, meaning his red Honda. B agrees to buy it, thinking A means a blue Maruti also parked there. There is no real meeting of minds. So A intended to sell his red Honda, but B wanted to buy the blue Maruti. Okay, so there is no meeting of minds between A and B. So there is no real contract and the agreement is void. Let's see the next doctrine, which is the doctrine of caveat emptor. Okay. The doctrine of caveat emptor is also a Latin term, which means let the buyer be aware. A buyer must examine goods carefully before purchase. A doctrine helps distinguish ordinary sales talk, which means puffery, from actionable misrepresentation or fraud. Okay. So, as I said, that caveat emptor means let the buyer beware. It distinguishes between puffery and misrepresentation of fraud. For example, if I'm trying to sell my car, I will sell I out of boasting my car, I'll say that this is the best car in the world. I've taken good care of it. It's probably the best owned car ever. But this does not mean I'm making a fraud attempt. Okay, this means I'm just praising my car. It's a puffery. So let's see the example. Seller says this is the best phone in the market. This is a mere puffery. Buyer must judge for himself. But if the seller hides a known manufacturing defect, that crosses into misrepresentation or fraud. Let's see the next doctrine, which is the doctrine of quantum merit. As quantum merit means as much as is earned, and it allows a party to recover the reasonable value of work already done when a contract is discharged before full performance, especially when one party partly performs and the other prevents completion. Okay, so it means as much as he deserves. It allows party to recover for work that he has already done. Okay, so let's see an example. A is hired to build 10 rooms for rupees 10 lakh. After rooms are built, the owner stops the project without a cause. A can claim reasonable payment for the 6 rooms he actually built. Okay, so if even if the project stopped in between, he can still claim the money which he actually deserves, as the doctrine says. So he deserves the money for the 6 room that he built. Okay? So this is the doctrine of quantum merit. Now let's see the next doctrine. This is the doctrine of restitution. It is the section 66, 64, and 65 of the Indian Contract Act. When a contract is discovered to be void or is later voided, the party who received the benefit under it must restore that benefit or compensate the other party for it. So it basically means like a refund. If a contract becomes void after the payment, the beneficiary must refund the paying party the amount or restore the benefit to him. Okay. So example to it is A pays an advance for goods. The contract is later found void due to bilateral mistake. A is entitled to a refund and must return any goods already received by him. So here A has paid for his goods, but the contract later becomes void. So A will receive the money back from B, let's say, and he'll get a refund for the money he has paid, and he also must return the goods that he has received. Okay. Let's see the next doctrine. This is the doctrine of promissory estoppel. So it could be used to recover damages when the promisor makes a promise on which the promisee relied upon to make certain financial decisions. Which means when a party relies on a clear promise to their detriment, the promisor is stopped from going back on it, even without formal consideration. The government promises tax exemptions to companies that set up factories in the backward region. Companies invest crores relying on this promise. The government cannot later withdraw the promise to their detriment. Okay, and if they do, the company is, has a legal right to demand back the money. Case law is Union of India versus Anglo-Afghan agencies, which is the leading case. The last doctrine which we are going to study is doctrine of undue influence, which you all might have come across. This means that covers relationship where one party is in a dominant position, which is under Section 16 of the Indian Contract Act. Courts presume undue influence in certain relationships and shift the burden of proof onto the dominant party to show the transaction was fair. Okay, so it means that where one party is in a dominant position and can use his position or power to enforce promises. Okay, these kind of promises are generally void. Burden of proof here shifts to the dominant party to prove that he was not influencing. Okay, an example to it is a doctor persuades his seriously ill patient to gift him valuable property. Because of the doctor-patient relationship, undue influence is presumed. The doctor must prove that patient acted with free, independent consent. So, presumed dominant relationship, parent-child, doctor-patient, solicitor-client, and similar fiduciary ties. Let's say, take an example of a doctor-patient. For example, if a doctor asks me to, if you want treatment, you'll have to give me 10 crore rupees or you'll die. So here the doctor is using his position to to influence me into paying him 10 crore rupees for a simple treatment. Okay. That was it for this. Thank you so much for watching CLAT 1. Please subscribe to our channel. We'll be uploading more CLAT related videos very soon. Thank you so much.